Matthew Mobilio, founder of the Mobilio Wood Law Firm here in Allentown, Pennsylvania. We serve all of eastern Pennsylvania, including Wilkes-Barre, Philadelphia, Lehigh, Northampton County, Luzerne County, Lackawanna County, and every other county in eastern PA. In this video, we're going to talk about being sued for custody. You've been sued for custody, now what? It's not as uncommon as you might think. Typically, when parents can't figure out what the right custody arrangement is for their kids, or there's some dispute as to existing custody arrangements, they go to court and ask for the court to tell them what the custody arrangement should be. Now, the first step in any Pennsylvania custody lawsuit is a custody conciliation conference or a custody masters conference. Different counties call it different things, but it all has the same couple of the same common elements. The first step is a mediation. So some call it a conference, some call it a conciliation conference, but it's essentially a mediation that's held by a court employee who is an attorney, or at least was an attorney at some point, to act as a mediator. What does a mediator do? A mediator listens to both sides of the story, and they try to come up with a proposed resolution that's going to make maybe not everyone happy, but at least put an end to the dispute about custody so that the parents can go back to being parents and not just litigants. Now, that particular mediator, in most counties, at least in eastern PA, does not have the authority to enter an order against your will. And so what does that mean? The mediator is not a judge. The mediator in custody conferences has the ability and authority to try to help the parties come to an agreement. But if the parties can't agree, the next step would be for it to go to court for the judge, or for a judge to decide who gets what amount of custody. Now, I've heard horror stories from clients who go to a custody conference without an attorney, and they leave and they say, well, the conference officer said I had to do this, and he had to do this in the order, or she had to schedule do things a certain way with regard to vacation or holidays or whatever it might be. That person, that conciliation officer, does not have that authority in most counties. There are some counties like Monroe County where the custody officer could enter some type of initial order or make a recommendation to a judge to enter the order. But typically, like here in Lehigh and Northampton County, if the parties cannot agree on a custody schedule at that first conference, that first conciliation conference, no matter what that mediator says to you, no matter how they make you feel, no matter if you think that person has authority to make you do something, they don't, and you can say no. For instance, mom files for custody against dad. Mom wants dad to have no overnight visitation with their child whatsoever. Dad shows up to his custody conference. The custody conference officer says to dad, this is a really good deal. You should take it. If you don't agree, you say no. End of story. No matter how many times that custody officer might try to push you or bully you or suggest to you that this is the only possible outcome, you say no. Because if you say no, that custody officer cannot enter an order forcing you to accept what's been proposed. The next step in that process, if there is no agreement at the custody conference, is going to be a hearing before a judge. Now, when you get to a judge, the judge has the authority to tell you what custody you're going to get with your child. So you want to obviously try to avoid that at all costs, because no one wants to be told what they can do and can't do with their child. But if there is no agreement at the conciliation conference, there is no other choice but to go to a judge for a final determination. Now, if you have questions about the custody conciliation process or custody process in general, give us a call here at Mobilio Wood, 610-882-4000, or email me, Matt, M-A-T-T, @mobiliowood.com.